Good morning. This is the courtroom clerk. We're not on the record at the moment, but we're getting ready to get started. It's going to be another couple minutes, but this is a reminder that everybody on WebEx needs to make sure that they are muted entirely with their video turned off and that The Circuit Court of the State of Oregon for Multnomah County is now in session. The Honorable Christopher Ramras presiding.
All right, please be seated. And Mr. Overstreet, if you want to call the case.
Yes, good morning, Your Honor. We're here for State of Oregon versus Nancy Crampton Brophy, case number 18 CR 59251. Appearing on behalf of the State of Oregon, Sean Overstreet, Overstreet, bar number 114859. Ms. Brophy is present, currently in custody, represented by counsel, and today's the date and time set for some late in trial motions.
All right, Ms. Herman.
Good morning, Your Honor. Nicole Herman, HERMANN, bar number 126353.
And good morning, Your Honor. Madeline Loeb, spelled L-O-E-B, bar number 173970.
All right, Ms. Weinmiller.
Morning, Your Honor. Chris Weinmiller from Ms. Brophy. Weinmiller is W-I-N-E-M-I-L-L-E-R, and my bar number is 863177.
Good morning, Your Honor. Lisa Maxfield, also here for Ms. Brophy. My bar number is 844337, and my last name is spelled M-A-X-F-I-E-L-D.
All right, and we do have a number of motions, but what I want to take up first are the various motions to quash. I have two, but I believe there may be three. So I guess I will just ask. I'm told that there's a Mr. McDermott present. And Mr. McDermott, I'm assuming, but maybe I'm incorrect, that there's a motion to quash for your client, which I may not have been able to see yet. Why don't we have you come forward and just put your name on the record? And
Thomas McDermott of Lindsay Hart, LLP, bar number 762430. McDermott is M-C-D-E-R-M-O-T-T. And we're here in response to a very short leash subpoena. I did not have an opportunity to actually file a written motion to quash.
okay, but you'll be presenting an oral motion.
Yes, Your Honor.
Okay, all right. I just wanted to find out. I don't want to hear it just yet. I kind of want to take them in a particular order. So, is the attorney for Ms. Parker present? All right. So, Ms. Shu, if you can come forward, why don't we have you put your name on the record, and I think we'll take your motion first.
Thank you, Your Honor. Sheen Shu, bar number 004282, here on behalf of Judy Parker, with respect to a subpoena that was served on her yesterday, requiring her to appear and testify today, as well as bring her client files.
All right, and just so you know, I did read your motion, and I just really sort of had one question about it, and then we'll let you argue whatever you'd like. I know you raised various different bases for granting the motion. I want to talk, though, about a portion of it, which goes to the vagueness and overbroad nature that you say the subpoena has. Do you have a copy of the subpoena with you by any chance?
I do not believe it's attached to my declaration.
It
Your Honor.
is. No, I know that. I asked because the subpoena is sort of broken, I think, can be broken up into maybe two different requests. And the first thing that it requests is your files, including records on electronic communications of fraud you understand to have been perpetrated on you or in your name. Now, I realize that the words "your files including" implies that it may be broader, but I guess my question is, with regards to the language about files, if they exist, that are records of fraud against your client, perpetrated on your client or in your client's name, I'm wondering if you have the same kind of objections that you have to the remainder of the subpoena. The remainder of the subpoena, for example, you have objections. Of course, you have to everything objections based on the time period, but you have objections based on potential attorney-client confidence. You have the ORCP objection. I'm just trying to sort out in my own head whether or not your objections are the same for that particular component of it.
Your Honor, it's my understanding after speaking to defense counsel that they are indeed seeking materials from Ms. Parker's client files.
No, I understand. I see that.
Right.
And that's, to me, that's a totally different issue. I guess I'm just wondering, I guess because I'm trying to figure out, I mean, let me ask it this way. Would it be your position that my authority would either be to quash the subpoena in its entirety, or do you think I have the option to allow parts of the subpoena to stand?
Well, I suppose if your honors, and again, I'm just jumping into
Sure,
this
of
late
course.
yesterday.
I know.
And, you know, let me think about it. I think if your honor's question is, if there are items that are not in any client files that's somehow evidence of any fraud against Ms. Jacobs, I personally am uncomfortable producing any documents without Ms. Jacobs' knowledge or opportunity to provide her to object. I mean, this is not a typical situation we're in, where typically when I appear before the court on behalf of a client who's been subpoenaed, the person's the client file, that client is usually represented by counsel. That counsel can object. Here, I don't even know if Ms. Jacobs is aware of the subpoena. So there is a much bigger issue. I understand, and I admire defense counsel's zealous advocacy. Every lawyer needs to have certain obligations to their client. And here, I'm just extremely uncomfortable with the fact that Ms. Jacobs is probably unaware of the subpoena, is unaware that materials are being sought to be used against her and that her former lawyer is being asked to testify, possibly against her, without giving her the opportunity to at least object and voice whatever objection she has, or if she is represented by counsel, maybe have the lawyer object on her behalf. Given the short timeline, I don't have time to even figure out what Ms. Jacobs' position is.
Okay, that was my only question, but why don't you, I don't in any way mean to shortchange you, your ability to put on the record anything you'd like about the subpoena, so why don't you go ahead?
Your Honor, I mean, we don't really have a skin in the game. I mean, I don't represent any of the parties. I'm just going to rely on what's in the written motion itself. I just want to make sure that the objections are in writing and on the record. And I'm just going to rely on the fact that the rule clearly requires that Ms. Parker be given 20 business days to respond to subpoena for her documents, and she was not given 20 days. She was given less than 24 hours. Again, I have obviously issues with the quote term files, and I confirmed with defense counsel there are indeed seeking materials from her files and also from my files, to the extent any of my communication with Judy Parker might somehow implicate or be evidence of against Ms. Jacobs. With the non-privileged portion, again, absent a court order, I don't think Ms. Parker could testify about a representation of Ms. Jacobs or reveal any information related to her representation. Because simply put, the client has not given informed consent, so the only other exception I can think of here is if the court orders us to do so.
Right, and your position is that ORCP 1.6 is even broader than the attorney-client privilege?
It is, absolutely, Your Honor. If you read the plain text of the language, shall not reveal information relating to the representation of a client unless the client gives informed consent. And that is impossible to obtain in such a short timeline.
All right. Okay, thank you. And I'm not sure who on the defense side. It looks like Ms. Weinmiller would be
That's
making
why I
the-
look so relaxed.
All right.
Good morning, Your Honor. When we issued the subpoena, we were not aware of Ms. Zhu's representation. Judy Parker herself is a lawyer. We know her, and we'd had some contact with her, and she had indicated that we would need to approach the court for a ruling under RPC 1.6, and we were prepared to do that. So we sent the subpoena to get that process started. We did then have a fairly lengthy conversation last night with Ms. Zhu, and what we tried to explain to her, what we did explain and what we spent some time trying to talk through is clearly this is a situation where the lawyer has two hats. She is lawyer and apparently represented Ms. Jacobs in a fraud matter, and I'm not even sure exactly what that was, whether that was prosecuted and what the outcome was, although I do know it had some relationship to the litigation in Hood River, which then it was part of the litigation in federal court. But she then became victim. Her second hat was that she was victimized because Ms. Jacobs took on her identity and apparently made contact both with the Hood River Circuit Court and with Wells Fargo, pretending to be Ms. Parker, told Wells Fargo that a motion to quash had been granted, and so they did not need to produce records that had been subpoenaed. I believe by Eric Haney's counsel from Perkins Coie. And then she reported that the case was settled, or that at least some aspect of the civil case was settled, to the clerk in Hood River County Circuit Court. Our understanding is that Ms. Parker then, when this deception was discovered, was interviewed by an FBI agent and did, presumably invoking RPC 1.6, spoke with the agent, answered his questions, disclosed that that was not her who made those calls, and helped them piece together what they needed to do to proceed with that. And I think that that is in part what the U.S. attorneys presented to Judge Hernandez in the federal court proceedings. And that was, I think, part of what then led Ms. Jacobs to be in custody in Multnomah County, where she came into contact with our client. So it's a very, very convoluted story, but Ms. Parker plays a pretty critical role in it. We're not nearly as interested in anything having to do with her representation as a lawyer as her position as victim. It is, though, and I think as we go through these with other lawyers, I think it's challenging in this instance to figure out exactly what's part of the privileged file and what is something that is no longer privileged. What any of us as lawyers would initially consider privileged, but perhaps may have lost its privilege through a series of events that have transpired. With respect to Ms. Parker, our position is that when she, taking on the victim role, and I don't mean that in a disparaging way, but with that hat on as a
Right.
victim, spoke with the FBI agent and participated in the federal prosecution and revealed the fraud that had been perpetrated in her name but without her knowledge, that waiver holds through this proceeding, that we now have the right to get that same information from her. One of the things that we were discussing last night with Ms. Xu is that we were getting caught up in the definition of what's in the file. And so we were positing to her, at least theoretically, they're really two different files. One is the lawyer file, and then one's the victim file. And it may be that Ms. Parker has actually put things in the lawyer file that we think of as being separate, and perhaps things that should have gone in a different cardboard file. But obviously, where the material is located isn't as important as which bucket it goes into. That then became further complicated because she was explaining to us that she represented her even then. She represented Ms. Parker even then, and was involved in all of those negotiations, and she was the one who was actually interacting directly with Perkins Coie and having some of these conversations about Ms. Parker as, client with the victim hat on. And so we thought initially what she was suggesting is that she might be the proxy or a substitute witness, and then realized that wasn't really what she was proposing. So I don't know that there's information in her file that's important. When we issued the subpoena yesterday, we didn't even know she had a role in the case at all, or that Ms. Parker was represented. So the subpoena wasn't intended to cover her, and I think arguably doesn't. But that's our position, that it's difficult to say what's privileged and what's not, because things that initially were privileged probably no longer are. Our position would be that at least a portion of what was in her legal file is no longer privileged.
And what would you say about Ms. Xu's argument that even if privilege has been waived on certain issues, it still falls under the broader prohibition of ORCP 1.6?
That the rule allows the court, for good cause, to direct compliance, and we believe that this information is material, and we would ask the court to make that finding. I think that gives Ms. Parker considerable protection. Certainly the RPCs contemplate that the court has the authority to make those kinds of rulings and directions, and we are asking that the court do that here, specifically with respect to anything that has to do with her role as, with the victim hat role. And I can think of a more legal way to say that, legalistic way to say that, but essentially that's the distinction. I don't know that there would be anything in her file that would go to Ms. Jacobs trying to use cooperation to further her position in the matter that Ms. Parker represented her in. But if there's a history of Ms. Jacobs trying to negotiate her way out of her legal troubles, which are very significant and very longstanding, you know, if she has a whole pattern of trying to negotiate her way out of trouble by providing cooperation against others, then we do think that part of the legal file would be germane. But we cannot represent to the court that we know that that sort of material is present in Ms. Parker's file.
Sure. All right, so Ms. Shu, let me ask you this, because I don't know if this is a practical impossibility or not, but I want to give you some of my thought process so you can respond accordingly. I guess there is a part of me thinking, if there is information solely related to Miss Parker as a victim, in other words, really nothing to do with her representing Miss Jacobs, but more having to do with records she kept regarding her being the victim of a fraud. I'm not. I know you made the comment about being uncomfortable that Miss Jacobs wouldn't be here to object to that, but this is a subpoena to your client, not to her. So I guess what I'm trying to sort out in my own mind is whether or not, as a practical matter, such material, if it exists, could be segregated from the remainder of the file.
Your Honor, given the short timeline, I can just tell you, based on my understanding, there's no material that's not in a client file that would be evidence of fraud.
I see. Okay. All right. Anything else that you
Your Honor,
want?
I think the counsel implied that Ms. Parker somehow may have waived 1.6 or waived any privilege by speaking to the FBI or being interviewed by the FBI. I can represent to the court that she at no time during her interview with the FBI, who, by the way, the agent only asked her 3 questions, at no time did it relate to the representation of Ms. Jacobs. Her name did not even come up during the interview. And I believe the questions were somewhere along the line was, did you have any contact with Wells Fargo within the past year?
Oh.
Or did you file a motion to quash in the past year? Had nothing to do with, I mean, I assume perhaps the FBI agent, after getting the answer to those 3 questions that clearly did not relate to the representation of Ms. Jacobs, her name was not even mentioned, it simply was, you as a lawyer, have you filed a motion to quash in the past year? And the answer was no. And perhaps they pieced it together, but by no means did Ms. Parker waive any privileges or waive the requirement of 1.6 during the interview. And also, I mean, I actually just had this issue come up very recently, just 2 weeks ago, before another court, in which my lawyer client was against subpoena, and the court's ruling, I think, is that the proper ruling is that a lawyer should not be required to testify regarding the representation of a client unless the party seeking their testimony can show 2 things. 1, it is crucial to their case, and 2, there are no other means of obtaining the same type of information other than requiring the lawyer to testify. Here, it's my understanding that Ms. Jacobs has been convicted of crimes. I don't understand why, for example, those judgments, for example, cannot be used against her to go to her credibility or her character.
Okay. All right. I am going to grant the motion to quash the subpoena to Ms. Parker for the reasons that Ms. Shu has stated. I will tell defense that this, and perhaps my decision on other motions to quash, may have sort of an ancillary significance as far as what I later decide regarding due process, but I am going to grant the motion.
Thank you, Your Honor.
And Your Honor, so there is a complete record. We're going to ask that the court maintain a copy of each of these files sealed in the record so that it's available for later review.
I don't even know if this file is here. I think given, can you come back up, Ms. Shu? So one thing I didn't specifically state, but I wish to, I mean, part of your objection was based on ORS 136.583 subsection 3, which requires 20 business days. And I will say, in reality, defense could not have done that since they did not know about the information until a much more compressed period of time. But with that said, I don't know whether or not you've brought a file today to.
No, Your Honor, I do not have my file. Ms. Parker does not have her file.
All right. Okay, thank you. I'll have you step back down. So, yes, but we can do it all at once. We can have everything on one. Did you want to put anything more, given that explanation, Ms. Weimiller, did you want to put anything more on the record?
Well, two things, Your Honor. First of all, we believe that as the testimony develops today, it will be clear that the federal authorities were well aware of the fact that Ms. Parker represented Ms. Jacobs in a fraud matter, and that tie-up was made very, very quickly, I think probably in that same interview. The representation that all she did was answer a couple of questions and then had no further involvement, I think does not fully and accurately depict the extent of that involvement and the extent of her knowledge. But I also am unclear. I think that the court is willing to take the file and seal it, but that was kind of.
Well, I'm not certain that I am. I just wanted to first even establish if that was an option, if it were present here today, and it's not. I don't think I am willing to take it and seal it if I am granting the motion to quash.
Okay, well, we are making that request, and we'll
Sure.
be making that request with all of the other files.
Sure. And then is Mr. Thompson here? All right, why don't we have you come forward? And this is pertaining to, and I apologize if I mispronounced the name, but John Seng's motion to quash a subpoena. Mr. Thompson, why don't we have you put your name on the record, spelling the last name and providing your bar number.
Judge Elliot Thompson, THOMPSON, bar number 160661, appearing today on behalf of John Seng, as well as the Oregon Department of Justice.
All right, and I have read your motion to quash as well, and I realize that one of the bases is there's an active criminal investigation that's still ongoing. But what else would you like me to know?
Well, Judge, I want to be clear that my clients, and I should have been more clear about this in the motion, but because the subpoena seeks records from the Oregon Department of Justice, I'm here today on behalf of both John Seng and also the Oregon Department of Justice. And certainly my clients are willing to do whatever they can to help the court and the parties achieve an equitable outcome in this case. That said, we do have some concerns. First of all, John Seng is not able to be here.
He's out of state. I
morning.
didn't see that.
It is possible he could testify later if the court finds that necessary. I spoke to him last night after speaking with the parties. He could potentially be available to testify this afternoon. Secondly, with respect to the documents, we're talking about in excess of 10,000 pages. And so my client's concerns would be, one, are they going to be able to comply with any order of this court, practically speaking? And number two, we want to preserve the confidentiality of both this pending criminal investigation and prosecution, as well as the confidential information that's contained within those records.
Okay.
And of course, there's the issue of relevancy, depending on how the court rules with respect to Ms. Jacobs' testimony.
Well, right. I mean, I know you brought that up as one of your objections. One of the things that's currently unknown, since this is an ongoing case, but my understanding is that the Department of Justice has reached out to a law firm that may or may not be representing Ms. Jacobs to discuss the case. One of the things that I don't know and defense doesn't know, but would certainly be relevant, is whether or not Ms. Jacobs was getting some form of consideration for cooperating in either this case or any other case, and that's just not known right now. So I guess to me, that would be the relevance. I don't know if there's anything you can say about that.
What I would proffer, Judge, and to be clear, I don't have anything to do with that investigation. I'm in a completely different section,
Sure.
division, building. But in speaking with Mr. Shang, my understanding is that he had no idea of Ms. Jacobs' involvement with this criminal prosecution until May 9th, when his investigator sent him a link to a newspaper article. So there was no consideration contemplated or offered at any point in time with respect to this criminal prosecution. And that's what he would testify to.
Okay. Is this also yours, Ms. Weinmiller?
Your Honor, there are two questions. Well, first of all, I do have a copy of, I don't have an exhibit sticker, but I have a copy of the letter, and Mr. Thompson may have brought one with him as well, but the letter that Mr. Sang sent to an attorney who is representing Ms. Jacobs, I think still is, in what amounts to a habeas matter.
And we do have a sticker if you need one, I think, right? Yes, we do have a sticker that you can mark.
Okay.
I'll just give you that sheet of stickers and then you can take that with you.
I know the state has seen this because they sent a copy last night.
Right. All right.
Your Honor, did you get the?
I did. I received, just so the record's clear on this morning, I received a copy of this letter from Mr. Overstreet.
I'm behind on my email.
No, that's all right. It would just essentially said, here's a copy of a letter that will be used in the hearing today. I'll just look and make sure they're the same thing.
And Judge, my best information is that Ms. Jacobs was appointed counsel, and counsel subsequently withdrew due to a conflict. And as far as I know, she has not yet been appointed new counsel.
Okay. All right, so Ms. Weinmiller, you got a little cut off there. This has now been marked as Defendant's Exhibit 400. Why don't you continue with what you were?
It has, and I cut myself off. So, Your Honor, our position is that there are two things here that could make it material. One is whether Ms. Jacobs had actually been offered something by any law enforcement authority or any prosecutorial authority. But the second is whether she knew that there was trouble afoot, whether she knew that she was facing further prosecutions. And that, I think, is the shoot or the posture that we're in here. I believe, and of course, because this is all very new to us too, but I believe that the Oregon Department of Justice investigation, this criminal investigation that Mr. Sang is handling, is related to and perhaps even fell out of a bankruptcy that just recently concluded. I believe the trustee in that matter filed his final report about a month ago. I think it was early April. And I don't know that I have a copy of his final report, but it involved the same business that Your Honor has the letter now, but Oregon Sleep Services Specialists, or that is the subject of Ms. Jacobs and the
Access Sleep. Is that what we're talking about? Access Sleep MD Professional Corporation?
I think so. It has, I believe that that's the same as the business that goes by Oregon Sleep Specialist Services LLC or something too. But in any event, in the bankruptcy, Ms. Jacobs is, it's solely the bankruptcy trustee and Ms. Jacobs and that corporation. It's not a bankruptcy that has multiple parties. It's fairly straightforward and fairly short file as bankruptcies go. But we think that that led to this investigation, or that they were at least dealing with the same subject matter, and that Ms. Jacobs knew, certainly by the beginning of this year, and probably earlier, that she was potentially facing additional prosecution. We believe that we haven't yet uncovered how many other potential prosecutions may be pending. We do, and I realize I'm going a bit afoot from, or astray from what Mr. Thompson's here to talk about in this motion to quash, but in that bankruptcy, there were allegations of bankruptcy fraud, and that, of course, wouldn't go to the Oregon Department of Justice. That would be something that would be investigated federally. So we're still pulling all of those threads, but the point that will carry through, I think, to some other of these motions, as well as Mr. Thompson's, is that Ms. Jacobs' understanding of what she might soon need to negotiate is absolutely material, especially for somebody of her sophistication. She's able to hold quite a bit of information in her head and think through various ways that she might move the pieces around the chessboard. And whether or not she knew that Detective Merrill was going to be showing up to talk with her, I think she knew that sooner or later that sort of thing was going to happen, and that she should position herself well for that purpose. So the discovery in that case that was just provided by Mr. Sang to the criminal counsel that was appointed. So the sequence as we understand it is Ms. Burrows gets this letter from Mr. Sang. She doesn't want to handle that criminal matter, and so at that point, criminal counsel is appointed. MPD was appointed to represent her. They got somewhat into the representation and then recognized that there was a connection to this case, and they, of course, had an earlier role in this case on Ms. Brophy's behalf, and so that presented an obvious conflict, and so they're now off the case. As Mr. Thompson says, I'm not at all sure that new counsel has been appointed. I think that MPD withdrew, and Ms. Jacobs may be in a posture where she's awaiting appointment of new criminal counsel. We don't know whether there were actual negotiations and whether in the course of those negotiations Ms. Jacobs' representative actually proposed or had proposed to her something, or whether that was still something that was being worked on within her defense team and hadn't actually materialized in that negotiation. But we do think that in addition to the discovery that was provided by DOJ to new defense counsel, so would have been within Ms. Jacobs' knowledge that way, even if it weren't already within her knowledge from the bankruptcy, that there could be some potential communications there that were at least starting this process of trying to negotiate some sort of better resolution. Mr. Thompson's and Mr. Sang, frankly, is in a much better position to know whether there is material of that nature in the file. I certainly hold him in very high regard and would accept a representation he made that no communication of that nature exists, but I think it's incumbent upon us to ask that he be directed to look specifically not just for offers that he made, but for even that sort of initial negotiation or posturing if things have moved that far. And we're also asking that we have the discovery so that we have some understanding of the magnitude of that case and also the scope of the fraud that the Oregon Department of Justice was investigating that has not yet been charged. And we think that because that was provided, they've at least put themselves in a posture where it's appropriate for us also to have it, but we would expect that there be a protective order and some restrictions on our ability to use it in any manner beyond the scope of this litigation, and we certainly have no interest in using it in any manner beyond the scope of this litigation.
Sure. Go ahead, Mr. Thompson. Anything?
Nothing further, Judge.
Well, so here's what I'm inclined to do, and you said that Mr. Sen could be available in the afternoon.
We discussed a possible 3 p.m. time slot, Judge.
Okay.
He should be available at that time. I can't promise it because of his travel.
Sure. I will tell you where I'm leaning on this, just so everyone understands. I do think we should get some further information from him, sort of specifically about whether or not any kind of concrete offer had been made, or, even a little more broadly than that, whether communications occurred starting the negotiating process and sort of what the content of those communications would be. I'm disinclined to allow a turning over of documents that are specific to the investigation itself, as far as the factual investigation, what exactly is occurring there. I'm disinclined to do that even with a protective order, but I would like to see whether or not he has anything to say regarding negotiation discussions. So why don't we plan to, I won't rule on this right now, but why don't we plan to see if we can have him testify later today and get a little more information on that point.
That's fine, Judge. Thank you.
And then, all right, Mr. McDermott, I know you came up first, but we'll have you come up one more time, and you've already placed your name on the record, so no need to do it again. But what would you like me to know about your client, Ms. McVicker?
Ms. McVicker, yes, Your Honor. First, I'd like to join, essentially adopt the motion that Ms. Hsu filed. Since she did a nice job, she was quicker on the draw than I was able to be, to put it in writing. We do have generally an objection that this is an unreasonable time limit, that there's a dispute as to what we knew, I guess, and when we knew it, but I'm here to tell you, we got the subpoena yesterday.
Oh, I know.
All right. Ms. Weinmiller sent me an email suggesting that the representations have been made by the district attorney that we've been working on this for several weeks. That's not true. There's another whole story as that we got a subpoena from my client got a subpoena from the district attorney that had to do with a very narrow issue. Were there notes in the file of Ms. McVicker that had to do with conversations between Ms. Jacobs and Ms. Brophy? There was a consent to search the file signed by Ms. Jacobs. So as a result of that, we did search the file and we found the notes, but then we raised the attorney-client privilege as an objection because we did not have, in fact, I think this is known, my partner, Nikki Jones, and Ms. McVicker spoke with Ms. Jacobs via video link, talked about what was being requested, and asked if she was knowingly waiving her attorney-client privilege to allow those notes to be produced. She did not give that permission or waiver. She said she wanted to speak with counsel before she would do that, so that she I'm paraphrasing because I wasn't part of that discussion, but
Sure.
my impression was that what I understand about it, she was not prepared to do that without some legal counsel on the pros and cons or what the repercussions might be. And that's where we stand. We told, Ms. Jones wrote a letter to Mr. Overstreet and said, yes, we found the notes, but we're not producing them because of attorney-client privilege. And to my knowledge, there was no follow-up after that. So that's the background of what we were looking for and why. What we got from Ms. Weinmiller is give us your whole file, which really on its face is unreasonable and absurd when you have an attorney, the oldest and most sacred privilege known to the law is attorney-client privilege. And to say, give us your file is just preposterous. And we've told them we're not going to do that unless and until we have an express waiver from Ms. Jacobs. Other elements, now there could be, I know it's potential that there could be documents in Ms. McIver's file that are not privileged because they're communications with law enforcement or otherwise. But we have not had an opportunity to search for any such documents. And we'd ask the court if we are required to do so, if you're going to allow them to get into some of our file. First of all, we need to hear from Ms. Jacobs again under the rules of professional conduct. And then secondly, we appreciate a real narrowing of what is it that they want us to produce and what, would be premised on some relevance to what they're trying to prove. I joined with Ms. Hsu in looking at the, if you will, rap sheet for Ms. Jacobs. And it would seem to me fertile field for telling the jury you can't trust what she's telling you. Why we'd have to invade the province of her prior attorney's file to find were there any negotiations about her plea bargaining. That just seems very intrusive and too attenuated to what's at issue in their ability to cross-examine her.
Yeah, so I'm clear, the matter that Ms. McVicker represented Ms. Jacobs for has concluded in the conviction?
Yes, well, in a plea. She pled to the convictions.
I see.
And she was sentenced in January of 2021. Her discussions with Ms. Brophy, while both were incarcerated, was after that sentencing.
Okay.
So those are our basic positions on this, Your Honor. We want to cooperate. We understand the severity or the gravity of the situation if someone's on trial for murder, and that they're seeking to get everything they could possibly think of that might help them. But I think that has to be balanced against certainly the attorney-client privileges. There's no basis to invade that in this case. And then as to the other potentially non-privileged documents, we're talking about a very large file. There were actually two convictions of fraud related to each other, as I understand it, with Judge Hernandez. And so there would be a lot of material to go through. And the premise of why would that be relevant to this proceeding? If Ms. Jacobs had negotiations before admitting guilt and pleading to these charges, I mean, that would be normal and natural that would go on. And we don't think it's in her interest to have all of that revealed publicly.
Okay. All right, Ms. Weinmiller?
Thank you, Your Honor. So this, Ms. McVicker is in the same firm as now Judge House, the Hovitt firm, and that firm is represented now by Nikki Jones and Mr. McDermott. We view them as being in a completely different position than Ms. Parker because this is the firm that Jacobs was working with as she was compiling this information that she now wants to offer up against our client. Now, the representation, I think, was limited to the two federal cases and the two federal cases that have led to convictions. There are actually 4 convictions. There are 3 in one case and 1 in another. The second case arose while she was on federal pretrial supervision for the first case. She then committed another federal fraud felony and was taken into custody. And it was at that point that she met our client and was housed with her. There are a couple of things that we're interested in from the legal part of the file. I don't know that it's hard to define these things without having an opportunity like this to engage and figure out exactly what's in the file. But specifically what we're interested in from the legal, still privileged part of the file is evidence of communications, attempts to float this information for benefit earlier, whether or not they were successful, and the communications that happened about why those notes were being held or kept in the first place.
Sorry, let me make sure I understand. You said attempts to float this information earlier. Are you talking specifically about information regarding your client, Ms. Brophy?
Right. And maybe I should have said this in the opposite order. So for some reason, and we haven't seen the notes and we haven't heard anything about this, but for some reason, apparently Ms. Jacobs tells either Ms. House or Judge House, I'm sorry, or Ms. McVicker that she wants them to take down notes about our client. So that happens during the course of the representation, I think, before the cases are resolved. We haven't been given an exact time frame. We've got some clues about it, but they were housed together for a fairly considerable period, and we really, at this point, don't have a good understanding of when that occurred and whether it was pre or post-sentencing. But they were housed together, at least intermittently, I think. And again, I don't have a timeline that I can present to the court, but I think Ms. Jacobs is taken into custody for violating her federal pretrial release by committing the new federal fraud for which she's now admitted guilt. That happens in August of 20. And then she was just moved. She finally was moved into a federal facility out of Multnomah County facilities in this year. We've seen different dates, but I think it might have been as recently as March. It was very recently. So there are 2 sets of things, and I want to not lose track of the one that has to do with her transport and her long stay in Multnomah County after she was sentenced. But going back to the point Your Honor just asked me about, communications about why she was asking her attorneys to take these notes down, and the back and forth about that, we think is germane to this, her motivation. And then whether her attorneys acted on their possession of that information to try to achieve a benefit for Ms. Jacobs in the federal case or in any other capacity, we think is also material and of great significance in this litigation. If we had issued a subpoena that said simply the non-privileged parts of your file, it wouldn't encompass that, because until the court makes a ruling under RPC 1.6 that's something that they need to disclose, of course they would consider that privileged, as any of us would. Now, the other issue that I just alluded to is things were unusual during the pandemic, and I do, as the court knows, most of my practice is federal. So I saw some of this occurring in my own practice. But even with the slowdown in the designations of BOP facilities and the transport delays that were occurring during the pandemic, to see somebody sentenced as Ms. Jacobs was in, what was the date of that?
January of 2021.
Yeah, I think if I have this right, she's sentenced in January of 2021, simultaneously on both of those federal cases. So they work out a plea deal, and it's essentially a stipulated 4 years, of which she's now served approximately 2 years. She isn't transported then for 14 months until March of 2022 into a federal facility. She's held at Multnomah County that whole time and continues to be housed with our client. And for all we know, that's the time period that she'll now claim she had these conversations with our client. We don't know, but it's just a very, very unusual and suspicious circumstance that she remained in Multnomah County for that length of time. I can tell the court, I've never had that happen with a client. I've never seen that happen unless the client was cooperating. That's just extremely unusual. So those two things are the things that could be privileged until the court rules that they're things that need to be discovered. But in her case in particular, with respect to the Hovitt file, we don't think that Ms. Jacobs, when she finally gets counsel and makes a decision, can lawfully be allowed to make a limited waiver of privilege and, to use Mr. Overstreet's term from 2 days ago, cherry pick what she's going to give us out of her attorney-client file. If she's going to produce anything at all relating to our client and to cooperation and to benefits and what she hopes to achieve, we believe that we need to get all of that. Again, we're not terribly interested in all of the discovery from their file. It could be that as we look through it, we would find something that we thought was significant, but our primary concerns are the ones that we've identified here. They are privileged now, but we think that they should not be if the event comes to pass that Ms. Jacobs decides that she does want those notes produced. We think all of that should, well, actually, I shouldn't condition it on that. I think if she's going to testify, all of that should be produced whether or not the notes are produced. But certainly if she's producing the notes, then the argument about limited waiver applies.
Is there, and I hear the argument, but is there any authority you can cite me to for the proposition you can't give a limited waiver of privilege?
Go ahead.
I'm just looking at a wonderful site from Holland and Knight. And if the court could give us until after lunch, we might be able to provide the court some authority on that.
Okay.
There is authority, Your Honor, and one of the cases I was reading last night was actually U.S. v. Patty Hearst, and I can find the site in just a moment, but essentially in that case it wasn't, Ms. Hearst attempted to testify, oh here it is, it's 563 Fed Second.
563 Fed Second.
1331, Ninth Circuit case from 1977.
And I'm sure it's a long case. Is there any particular?
I think 1340 was the page that was of interest to me.
Okay.
Yes, well, it might start on 1339, but
Okay.
it's right
around
around there.
that area. I just want to have somewhere that I could potentially start. Okay.
And that was one of the cases that I read last night. Now that one, it's a different concept of limited waiver. She was testifying and she tried in her testimony to carve out a period of about a year and not testify about that. And the Ninth Circuit's ruling was no, cross-examination has to be allowed on all points, that's not permissible. But we think that is analogous here, that Ms. Jacobs, in order for us to effectively cross-examine her, we have to have access to all of that other information about the very same representation, the very same attorney she went to take these notes and to discuss this with. We need the context that surrounds those notes and those events, and not just simply what Ms. Jacobs thinks would be to her benefit to give to us.
Okay. Go ahead.
Your Honor, it seems we're in a hypothetical. The assumption here by counsel is that Ms. Jacobs has released certain materials from her file, and that is not accurate to my knowledge. We don't know if she's currently represented. We haven't been able to speak with her. We don't know if she's authorized release of anything. As matters now stand, there's been no waiver of any attorney-client privilege. And so I think it'd be highly improper to start ordering us to release things from the file without the client's consent, or at least advice. So
And
if
what's your,
things change, you know, if Ms. Jacobs comes and testifies, or it doesn't have to be when she testifies, if she pre-testimony says, I'm fine, waive my privilege, give them anything they want, then so be it. That's her decision. But the lawyer, Ms. McVicker, can't make that kind of decision.
and defense didn't explicitly state this for this motion, but they have stated it for another, so I'm going to ask you the question. If I grant the motion to quash, what position, if any, do you have on providing a copy of the file to be sealed?
Well, I would make this representation that it's an electronic file completely. There's no paper apparently. And it would be maintained like it should be. Ms. McVicker's office would maintain that file and not destroy anything or get rid of anything. So it would be available in the future if the court decides that something in there has to be produced.
Oh, well, my understanding, but I'm going to let Ms. Weinmiller respond to this. I mean, what I assume Ms. Weinmiller was seeking was that it be sealed and made part of the record so that if there's an appellate issue that relates to due process and whether or not that's been violated, that a reviewing authority could consider what was in the file. Am I incorrect on that, Ms. Weinmiller?
No, Your Honor, you're absolutely right, and I think Mr. McDermott's client would understand exactly that that's what we were trying to accomplish, that we think it does need to be a part of the appellate record. They may choose to review the file in making their the court's determinations about these decisions. And I appreciate you bringing up the fact that I used sort of the future tense when I was talking about sealing the files, but let me say it in the present tense. We are asking that with respect to each of these motions to quash, that the court ask that a complete copy of the file be produced and it be made a part of the record in this case.
All right, so with that understanding, I just want to see if you have any particular position.
Well, it's two things, Your Honor. One, I forgot to mention this, that I don't believe I don't know if it's known when Ms. Brophy and Ms. Jacobs conferred about the subject matter in the notes. I do know that she was sentenced in January of 2021, and these notes were taken in March of 2021. So that's 3 months later after sentencing. So I think that there was an inference that it was somehow part of what was going on when she was sentenced. I can't say that they didn't talk before she was sentenced, but my client had no involvement with taking any notes until March of 2021. As to the file, I assume we're talking about submitting something to the court under seal that would not be accessible by counsel.
Right.
I still think that that's a very, I haven't faced this before, but you know, to have attorney-client privilege materials out of my client's control and subject to maybe some clerk wants to look in there and see what's in there. I mean, that just strikes me as very dangerous until we have a better idea of what exactly Ms. Jacobs what her position is on the privileged materials in her file.
And do you have any particular time frame that you're anticipating hearing her position on that, or not really?
We don't know. Last we knew, she's in Texas. She's been ordered to come up here to testify, or she's been transferred. We don't know if she has counsel. We'd be happy to talk to her counsel if she has it. And if she doesn't have counsel, honestly, Judge, I think you should appoint counsel for her on the subject of waiving her attorney-client privilege. Because that's something that Oregon law requires it to be knowing and voluntary.
Sure. And that may well happen, but I mean, right now, she's not even in the state of Oregon. So at least as far as I understand, so I don't know that I really have authority to do that right now.
I would represent to the court, we will maintain the integrity of this file, but
Okay.
Oppose having to submit it to the court under seal at this time until we
Sure.
know more.
Sure. So here's what I'm prepared to do. I'm going to grant your motion to quash the subpoena. I'm not going to order a copy of the file be submitted under seal yet, but I will indicate to you, Mr. Thompson, that that's a real possibility depending on what develops. And I'm also, since I don't expect you will necessarily be here when that determination is made, just as a practical matter, would the thought be that we would contact you when such decision was made, or would you want to be present in some capacity?
Oh, I think either myself or my partner, Nikki Jones, would welcome the opportunity to at least be present when this is debated again.
And how far in advance would you need to be notified?
I'm available all next week, so, and I understand
Okay.
the court is intent upon getting us to the jury by the 20th.
We are?
So we'd be, one or the other of us would be available on half an hour's notice.
Okay, all right. Then that's what I'll
I
do.
have to leave it, a coat and tie in my office. To
Okay, all right.
All right, should we submit an order, Your Honor, for this ruling, or I'm not sure?
We can draft the order.
Okay, great. Are we concluded?
We are done, yes,
Thank
for
you.
today, at least. All right, so I think that's sort of, we have two more motions to take up. It makes sense to start with the defense motion to exclude informant testimony. I have now had a chance, is this, who's going to argue this motion?
Here, actually, we would like to produce some evidence.
Oh, sure, absolutely. I'm just trying to know who I should address as I talk to. Okay, all right. So Ms. Weidenmiller,
Wait,
I don't
this
know.
is your motion.
Oh,
This-
we need,
that's okay. I'll give you a minute. But here's all I'm really trying to get at while you two are sorting that out, and we can even take a break. But what I'm trying to get at, I understand you do want to produce some evidence on it, which we will do. But whoever's going to present it, you're certainly entitled to make opening comments if you want, or you can save the argument until after the presentation of evidence. It's up to you. So whoever's going to handle it, that's sort of the format we'll follow. Oh, why is Mr. Hartley here?
I just messaged you all of that.
Yeah, I haven't been able to
No,
see
that's
any
okay.
of that. Hold on just a minute. There may have been something else that has cropped up that I'm unaware of.
Some targeted blows.
Oh, I see. Okay. Sorry, just so.
We're on mute, 1 second.
Just so defense knows, one of the witnesses who's potentially providing evidence for the motion is Mr. Hartley, who is present in the courtroom right now, but does have other obligations from 10:30 to 12:30. So,
I think Mr. Hartley, although he's not moved to quash, is in a position similar to the other people. He's come to the court under the professional rule. I think he believes there are parts of his file that are not privileged, but he would need a court order to disclose that. Am I correct, Mr. Hartley?
why don't we have Mr. Hartley come
Yeah.
forward, and we'll have you place your name on the record and be identified, but then pause before we launch into argument. But go ahead and place your name on the record.
Of course, and good morning, Your Honor. Grant Hartley, Hartley, bar number 143353.
All right, and just so I am clear, he is potentially a witness for the defense motion to exclude informant testimony?
No, Your Honor, I think that we subpoenaed, as we did, other people who we believed had records that were pertinent to Ms.
Okay.
Brophy's defense. We subpoenaed Mr. Hartley's file. Is that,
All right, go ahead then, Mr. Hartley.
That is correct, Your Honor, yes. And I received the subpoena on May 10th, and after a conversation with Ethics Counsel, I am objecting to the production and I'm moving to quash on the grounds that any information would fall under my duty of confidentiality under RPC 1.6. That obviously would extend not only to the privileged communications, but also to any information that could embarrass or harm the former client as well. And so at this time, without the client consent or a court order, I cannot produce any of that non-privileged information, which I believe would include even indicating whether or not I have responsive documents to the subpoena.
All right, and just so I'm clear, we're talking about Ms. Jacobs as the client?
That is correct.
Okay.
And so I was the individual that was appointed the pre-charge. And so I was appointed by OPDS, I believe on April 20th.
April what?
20th
Of what year?
of this year. Very recently.
You were and I'm sorry, forgive me, my slow to track this, but what were you appointed for?
With regards to the pre-charge representation for the Department of Justice investigation.
Ah, okay. Thank you. All right, then I will,
Your Honor, can I just make one other
Sure.
point for the record?
okay.
It's our understanding, I know that the Department of Justice has said that they are asserting some sort of confidentiality regarding the investigative nature of their file and the fact that they have, I think,
Sure.
probably 13,000 pages of investigative records. It was my understanding in talking with counsel for DOJ yesterday that all of that discovery has been provided to the Public Defender's Office, so that there has been a sharing of that information outside of the agency. And we believe that it's kind of left its investigative state, and I think even the letter from counsel to Ms. Burrows would suggest that it's no longer investigative material. It's now material that has been disclosed to Ms. Jacobs' attorney, and we believe that we're entitled to that.
All right, and I have not ruled yet on the DOJ motion to quash, but just so I'm following you, the 10,000 plus pages or so that Mr. Thompson referenced you believe also may exist with Mr. Hartley's file?
Yes, in other words, DOJ, whatever confidentiality it may have had in its investigative state, now has changed, and now that file has been shared with defense counsel for Ms. Jacobs.
All right, and I saw your sort of confused expression when I said I hadn't ruled on DOJ's motion to quash. I guess I may have partially ruled on that motion. But I hadn't heard this particular argument. So we may have to revisit the DOJ motion to quash. But with regard to Mr. Hartley's motion to quash, I'll go ahead. Anything, well, I guess I should ask anything more defense wants to say.
No, I'm just saying, I think counsel's saying he can't tell the court whether there are non-privileged documents within his file, but we have reason to believe, based on the representations of DOJ, that at least there are 13,000 non-privileged documents sitting in his file.
Okay, I understand. All right. Anything more that you want to say, Mr. Hartley?
I don't believe so, Your Honor. Again, without a court order or client consent, I cannot disclose any.
All right, so coming back to defense, so I guess what you're asking me to do, I want to make sure I understand, is at a minimum compel a turning over of non-privileged documents?
Yes, Your Honor.
All right, so I know you can't tell me whether or not there are non-privileged documents, Mr. Hartley, but just with regard to that concept, maybe you already made the argument, but let me know your position on that.
Well, Your Honor, I would be objecting based on RPC 1.6 is that documents, even if non-privileged, are considered confidential. And so RPC 1.6 prohibits me from disclosing that information.
Okay. I want to hold off on ruling on this motion. I realize, Mr. Hartley, that you are going to be tied up. I have until roughly, I guess, 2 o'clock or 2:30.
I do have other obligations. Actually, I'm booked until 4:30. I can probably move some of those around if the court can give me a specific time. I will be back over here plea at 1:30 if that helps.
Well, why don't we plan on, I think I can, it may be incumbent upon me to hear testimony from Mr. Singh in reaching this decision. So, can I have you back at 4:30?
Yeah, I can do that.
Yeah.
Is that all?
Yes, I think
Great,
so.
thank you,
Thank
Your
you.
Honor. Yeah, just to clarify, Mr. Overstreet just asked whether or not I represent Ms. Jacobs at the moment, and to be clear, I think it's already been stated, I withdrew due to a
Right.
conflict, and that withdrawal happened on May 2nd.
I did hear that you no longer represent her.
Thank you.
Okay, all right, shall we take our morning break then and start up? Let me ask the sides, because I'm trying to figure out timing on all this. If we take a 15-minute break, how does defense sort of see the presentation of the various witnesses? How long do you think all of that will take? And
It's not going to be orderly, I can tell the court that. But we do have Alicia Hersher, who is here to testify with respect to one point.
okay,
And because she has to be somewhere at 11,
we could take her testimony now.
quickly, yeah.
Okay, let's do that. So Ms. Hersher, if you want to come on up. And well, let me ask, does anyone have any real preference as to where she testifies from? I
No.
guess, you know what, Ms.
She's an
Hersher,
officer of the court.
why don't we have you come on up, just because it'll be more comfortable and you'll be by a microphone. So
Every lawyer ought to have to see here once.
there we go, yes. Okay, so we'll have, my clerk will give you a note.
Okay, I'll ask you to please raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yep.
Okay, then you may be seated and you may remove your mask. And then,
Oh, thank you.
because we're being recorded, I'll
Well,
ask.
let me ask actually on the mask situation, since we don't have a jury here, is anyone really requesting that she remove her mask?
She can do whatever she chooses.
All right, so we'll leave it up to you, Ms. Hersher.
I'm fully vaccinated ×4.
Okay.
And then could we have you please state and spell your first and last name?
Alicia Hersher, ALICIAHERCHER.
All right, when defense is ready.
Thank you. Good morning, Ms. Hersher. Were you representing clients in this county back in, I guess it would have been 2020 and 2021?
Yep.
And I believe that it was sometime in January or February of 2021. Did you have a meeting with Mr. Overstreet?
I would have had many meetings with Mr. Overstreet
Okay. Well,
about various clients.
I want to talk to you about, and I don't know who the first client is, but at some point when you were meeting with Mr. Overstreet with respect to a different client, did Mr. Overstreet make inquiry of you regarding a client of yours named Catherine Wells?
Yes, it came up in a conversation, a casual conversation we had. We were talking about various cases we had together, and her name came up, yes.
And can you tell the court in general, first of all, did you call Mr. Overstreet regarding Ms. Wells?
No,
Okay.
we were talking about other cases, and her name came up.
Okay, can you tell the court about the conversation as it relates to Ms. Wells?
So we were chatting, as we do, in the hall somewhere. I don't actually even remember when it was, a year or two ago, and about various clients. And Catherine Wells was my client, but not, I don't believe Mr. Overstreet, but it came up because she'd been looking for opportunities to settle her case in the best way possible. So we're chatting, and he said, well, she happens to be in custody with a person who I didn't know at the time named Nancy Brophy. I said, okay. And
Let me stop you for just a second. Did you tell Mr. Overstreet that you represented Ms. Wells, or did Mr. Overstreet ask you if you represented Ms. Wells?
I think it was common knowledge. I don't recall.
Okay, go ahead.
Yeah, there'd been a lot of talk everywhere about it. Apologize. I'm uncomfortable. Tell me where I left off.
Oh, you and he were having a conversation in the hall about other clients, and Ms. Wells' name came into the conversation. I think that's where we were.
Right. And he mentioned that she was in custody with Miss Brophy, and I said, okay. He said, I know she's probably looking for a way to resolve her case. if you want to ask her if she has any information about Miss Brophy and her case, would you be willing to? I said I could ask.
During that conversation, Mr. Overstreet already knew that Ms. Brophy and Ms. Wells were housed together?
That was my
Yes.
understanding.
Okay. And that was information that he first shared with you. It wasn't you sharing that with him. Is that correct?
That's what I recall. It was a
Okay.
long time ago, and it was very casual. So yeah.
At that time, were you a little bit nervous about approaching Ms. Wells regarding that?
No, this comes up both ways. Sometimes clients ask me to ask DAs, sometimes DAs ask me to ask, no, but I do remember though, because I felt a little bad about it. It was a week or two later that I was talking to her on the phone, Miss Wells, when I asked her if she wanted to share any information.
And did she respond emotionally?
Yes, she was very angry with me for even asking.
And Ms. Wells was incarcerated at the time, is that right?
Yes.
Did you and I have a conversation about that interaction?
Yeah, in fact, I hadn't talked to you a long time and I got a call from you. I don't know how, maybe a week or two later.
And in that conversation, did you explain to me that your client was very upset about other people maybe thinking that she was an informant?
I may have, I'm not, I don't actually remember that part. What I remember about our conversation was I said she was very upset with me, very angry. And then you mentioned something about a letter, but I don't remember exactly what. I was surprised you would call me since I didn't know you.
Has given authorization for you to share information regarding this particular incident?
No,
No.
I haven't spoken to her in a long time, and I'm not revealing confidences. I'm
Oh.
just talking about the fact I was asked to come to clarify my communications with the district attorney.
Okay. Ms. Wells is not a quiet woman.
She wasn't when I knew her. No, she was quite vocal.
And even based on the charges that she had, you knew that she was quite vocal within the jails.
That is my recollection. Yes, talking to a lot of different inmates. Yes.
She wasn't one of your clients likely to hide her upset from the other people she was housed with?
No.
Okay. I don't have any other questions. Thank you.
Any cross-examination?
Yeah, just a few questions, hi, Ms. Hersher. As far as the conversation between you and I know it's been a while, and it was very casual conversation at the time. You said you weren't 100% sure, or you weren't certain, but would it surprise you that you actually brought up Catherine Wells to me, that I didn't know who she was?
Yeah, it would surprise me.
Okay. And
although let me clarify something. I didn't make notes about it because it was such a casual interaction.
Sure.
I don't have any notes about it.
Sure. Would it surprise you that I didn't know that she was actually housed with Nancy at the time?
Yeah. It would surprise me only because that was the implication when we chatted.
Okay. So you don't recall you actually bringing up the name Catherine Wells to me and telling me that she was housed with Nancy, and then
I don't recall that, but yeah, I don't recall it. But as I say, we were chatting about a variety of cases.
Right.
And I'm a chatter.
Yeah.
So I would not, but I don't recall that.
Yeah.
No.
Okay. But you did state that Catherine Wells had come to you before this conversation. Catherine Wells had come to you saying she was looking for a way to get some sort of deal.
Oh, yes.
Okay. So would it make sense then to you that based on that information that you had, that she's looking for a deal, that you maybe would have approached me with that name and asked me?
I would have only done that if she had, the only time I ever approach a DA about interaction like that, about how they would be an informant, is if they have come to me and said, hey, I'm here with person A and they're confessing to something. I need you to reach out to get a deal. And that hadn't happened. And in fact, her reaction reflects that. She was
Yeah.
very upset with me.
Okay, I think that's all I have, thank you.
Let me redirect.
None.
All right, may the witness be excused.
Thank you.
Thank you, Ms. Hersher.
Yep.
All right, and before we called Ms. Tertier, Ms. Maxfield, I had asked sort of, I know you said the witness presentation will be not totally orderly, but I am trying to get some sort of a sense of timing. Because I really don't know how many witnesses are being called or what the expectation is on how long it will all take.
Well, I think, do you want to address?
I guess I do have a list, so I do have some idea how many.
Your Honor, I think we have at least 3 witnesses. It's not clear to us whether a 4th one has shown up, and potentially 5. But I know that there are 3 that we've seen, or
Okay.
2 of those are by WebEx. One of them is not available until this afternoon.
Can I ask, I'm looking at the sheet now, the potential defense witnesses, and I see one that looks like they have an attorney that we haven't discussed yet, someone by the name of Lindsay Burrows. Is this another matter that pertains to a motion to quash or not? I'm just trying to get a sense.
No, Your Honor, she is the person who was representing Ms. Jacobs on the habeas, and she got the letter from Mr. Sen at DOJ and then handed off that representation to Mr. Hartley.
Oh,
So
I see.
I think Mr. Sen was hoping that she would take that on, but she did not, and we do not have any reason to believe that her involvement or her discussions with Ms. Jacobs would have been more extensive, or that she would have attempted to involve herself in any way in that negotiation. She's represented, she did not. So
Okay.
she received a subpoena, but I think that we consider her to have complied with it.
Okay. Then why don't we take our morning break and be back on the record at 10:45.
All rise.
All right, please be seated. And are we ready for the next witness?
Your Honor, I have a matter
Okay.
that I'd like to bring up. Based on Ms. Herscher's testimony, I am asking the court to afford an opportunity for either a proffer on my behalf or allow for my own testimony.
Well, I'll tell you what I was thinking about that, and the way, since you are an officer of the court, I was taking the questions you were asking, which implied that Ms. Herscher was the one who in fact approached you, as opposed to you approaching her. If the point of your testimony or a proffer would simply be to reiterate that point, I'm comfortable. You asked it in the form of a question, but if your representation is essentially that she approached you and that you did not have knowledge that Ms. Wells was housed with Ms. Brophy at the time, I'm willing to accept that representation. Is there any further information that you would want to address?
Just a couple of minor details, Your Honor.
Okay.
One, that I have a very clear recollection of the conversation, mostly because of the content that it was. At the time, we had no informants. We had nobody approaching us. So the fact somebody was approaching me and telling me they had somebody that was housed with Ms. Brophy was significant, and it was very memorable. It did not occur in a hallway. It was a phone call. I was at home at the time. I do not recall whether Ms. Herscher stated a name of the person. The name Catherine Wells didn't mean anything to me before that, meant nothing to me after that. In fact, when I recalled the conversation, the name Catherine Wells did not ring a bell to me. Like I said, it was a phone call. She asked me if, she told me that her client was looking for a deal and that she was housed with Nancy Brophy. My response to that was, is this person willing to talk to me? And when she got back to me, that part may have happened in the hallway. Maybe that's what Ms. Herscher was recalling. And her response to me was no, and then she told me how furious that client was about being asked about that, about this particular person, Ms. Brophy. That's the content of the conversation that I remember very clearly.
All right, I'll accept your proffer on that, and again, as an officer of the court, I'll accept that.
Thank you, Your Honor.
So with that in mind, are there any, I'm sorry, who is the next witness?
So, Your Honor, just to clarify, what we're proposing to do is take testimony in both motions because there's so much overlap between the two.
Sure.
And go through the witnesses and then go back to, there will be 2 witnesses by WebEx as well. And then at the conclusion of that, have the
That's
argument.
totally fine.
Okay.
And let me ask Ms. Weinmiller, I made an assumption, but it could be entirely incorrect. Is Mr. Scott arguing the second of the 2 defense motions?
No, he had a number of obligations.
Okay.
So Mr. Dennison and Mr. Scott both helped with the memos.
Okay.
And made a substantial contribution, but neither of them is arguing today.
Okay. All right, then let's go ahead. Who's the next the next witness?
Donna Maddox.
Donna Maddox. Okay. Ms. Maddox, will have you come forward and go ahead and step into the witness box, and we'll give you an oath.
I'll ask you to please raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, then you may be seated, and because we're being recorded, please state and spell your first and last name.
Yes, it's Donna Maddox, Donna, last name Maddux.
All right, and Ms. Maddox, it's entirely up to you whether you wish to wear a mask or not, but if you're more comfortable with the mask, that's fine.
Thank you, Judge. I'm going to leave it off, and I am 4 shots.
Okay, all right. We're not asking for anyone's medical history. I just want to be clear about
Happy to
that.
volunteer.
All right. Go ahead.
Good morning, Ms. Maddox.
Good morning.
You are a former Assistant United States Attorney, are you not?
That's correct.
And what are you doing now?
I am a partner with a national firm, Lewis Brisbois, here in Portland, in the data privacy and cybersecurity section.
All right. When did you leave the U.S. Attorney's Office?
I left the U.S. Attorney's Office in September of 2020.
All right. In the last years of your time at the U.S. Attorney's Office, did you become familiar with a woman named Andrea Jacobs?
Yes, I did.
Were you assigned to that investigation and prosecution?
I was assigned both to the first and the second cases we had.
I'm going to hand you the sentence. Well, let me ask you one more question. Did you seek permission from the Department of Justice to testify today?
Yes, so for the record, Ms. Weinmiller contacted me on Wednesday and asked me if I would be able to testify in this hearing. It was unclear whether or not I was still governed by the rules of the U.S. Department of Justice. We discovered that I was, and so there was a back and forth with the department, and the department gave approval for me to testify today as to items in the public record already on these matters.
Okay, so the direction we both received is that we must stick to things that are in the public record.
Correct.
All right. I'm going to hand you government sentencing memorandum, and it has 2 case numbers in there, and I'd like you first to identify whether those are the cases that you were involved in prosecuting, the ones that you just
Judge, we
referred to.
don't have these.
We don't have a copy of any of this stuff.
All right, so before we get into it, also, I don't think we said for the record what it's been marked as. So let's make sure that the state has a copy or has had a chance to see this. But also, just so I know, what number has this been marked as?
It says 402.
Okay,
That's, yes.
Get a copy? Or should we just read it?
we can take a moment to get a copy. We can make a copy if need be, if defense doesn't have another copy. Is that the same thing, Ms. Weinmiller?
This is the plea agreement that corresponds
Could
to
we
the
have,
sentencing memo.
so maybe it'd be helpful to say, we don't have any documents from the federal case and haven't been provided with any from defense.
Your Honor, I am sorry that we assumed that they would have looked at these matters.
We don't have
Let's
access.
do
Have access
this,
to
let's
federal
do this.
documents.
I don't wanna get into sort of quibbling between the sides right now, but what I do wanna do is take a brief break so that whatever documents are going to be used in these motions hearings, we make sure that the state has a copy of them. So I don't know if this is the only document. Obviously, this wouldn't take long to copy the one document, but are there gonna be a variety of documents?
There are 3.
Okay, why don't we take just a brief 5 or 10 minute recess to get copies of those made, so my clerk can help with that. And then we'll resume. Ms. Maddox, if you want to step down, you can.
Thank you, Judge.
That appeared to be the sentencing memorandum that was filed in the two cases that you referenced just a moment ago.
That's correct.
All right, and what are those federal case numbers?
So the two case numbers are 18 CR 00427 and 20 CR 00177, both cases assigned to Judge Hernandez and out of the Portland office, which is the 3 designation.
All right. Now, you were, when you were still with the office and working on these cases, you were also working with an assistant United States attorney named Ryan Bounds.
Ryan Bounds began working with us on the 20 matter, the second matter.
Okay, so you were handling the 18 case on your own initially?
Correct.
Okay. So in that sentencing memo, would you tell us what Ms. Jacobs ultimately was convicted of and being sentenced for?
Correct. Given the sort of pendency of the first case and the charging of the second case during that pendency, there was a negotiated settlement for both matters at the same time.
Okay, and she did enter pleas to the counts of conviction, correct?
Correct. Different counts for the two different matters. Did you want me to read those?
I do, just to clarify, there was no trial in either case?
No.
Okay. And at this point, Mr. Bounds was filing the sentencing memorandum because the sentencing also was going to be simultaneous?
Yeah, it appears that the government sentencing memo was filed in December of 20, so I was gone by then, but was following the case.
Okay, all right. So in the first case, the 18 case, what were the counts of conviction?
Counts of conviction were count 5, filing a false tax return for 2011 for her personal taxes. Count 14, which charged her with impersonating an IRS employee. And count 15, which charged her with aggravated identity theft in furtherance of wire fraud.
All right. And then in the 20 case, was there also a conviction in that?
There are, but I will have to go forward. The 2020 case, there's a single count of conviction, and it's a bank fraud charge.
All right. Now, I'm also going to hand you what's been marked as Defendant's 403. And I'm asking you to identify that document.
So 403 appears to be the filed version of the plea agreement in the matter for both matters dated August 31st of 2020.
All right, and either by referring to that or from memory, can you tell us, just in general terms, what Ms. Jacobs' exposure was for the two cases?
Well, when you say exposure, do you mean the maximum sentence or the federal sentencing guidelines, as you know, Ms. Weinmiller, are very complicated. But in terms of the statutory maximum for that series, looks like we had 3 years of imprisonment for the false tax return, 3 years for false impersonation of an IRS agent, 2 years for aggravated identity theft, and a statutory maximum of 30 years on the bank fraud charge.
Okay, thank you. I will accept your representation that the guidelines are very, very complicated and probably not worth the time it would take to explain. So in that plea agreement, and that you said that that's the filed version of the plea agreement, correct?
Correct.
Okay, and because it's filed, that means it was accepted, correct?
This is the one that was submitted to the court, correct.
Okay. What was the agreement that the government eventually reached with Ms. Jacobs to resolve those two federal cases?
That agreement is the agreement that's contained in the government sentencing memo that we just discussed.
All right, and so just in terms of years, actual sentence of confinement, what was that portion of the agreement?
I will look to whether or not there was an agreement. This again has been quite a while for me. The agreement was a stipulated sentence of 4 years imprisonment.
Okay, and that covered both cases?
Correct.
All right. And do you have knowledge of whether that was in fact the sentence that Judge Hernandez imposed?
Yes, and in fact, it was a what we call a C1C. So at the time of presentation, the court would have had to give some indication about whether or not they were willing to accept the party stipulation.
And those pleas are relatively rare in federal court
Correct.
to get the
At least in the fraud landscape.
right, to get the judge to actually commit in advance of accepting the plea that the proposed stipulated sentence is acceptable.
Correct. They're disfavored.
All right, but in this case, Judge Hernandez did agree to do that.
Correct.
All right. Now, I'd like to back up a little bit and talk about what led to the point that that agreement was accepted. I'm going to hand you what's been marked as Defendants 401. Ask you if you're familiar with that document.
I am familiar with this document.
All right, could you tell the court what that is?
So this document is also a publicly filed document from the docket in both matters. It's a transcript of a appearance and detention hearing for Miss Jacobs when she was arrested on the second matter, the 20 matter. So this hearing served both as a violation of pretrial release hearing and also as a detention hearing on the new charges.
Okay. So when the 18 case began, you were working on that, you were solely assigned to that. You didn't have co-counsel at that time.
Early on, I believe it was just me.
Okay. What was the arrangement with respect to her release status in that 18 case?
She was on release the entire time. She had not been detained. It's unusual for me to seek detention on a fraud victim or in a fraud matter because of the rules around detention. You have to show risk of harm or threat of flight or non-appearance, and so that's a little bit more rare in a fraud case. So she had been out on conditions and was being supervised by pretrial.
Okay. And do you remember roughly how long she was out on supervision before this transcript, the events that led to the creation of that transcript occurred?
I don't remember when in 18 the charges were initially filed.
Okay.
So but it had been 18 indicates we filed it in 18.
Okay. All right. So what led to this hearing? And maybe from the transcript, you can tell us what the date of this hearing was, first of all, that you just referenced.
So the date of the hearing was May 28th of 2020, and I recall this very clearly. What led to this was Miss Jacobs' arrest on the new charges, which again then created both a hearing on was she in violation of her current agreement that she not commit any new crimes while she's on pretrial, and then also the issue of whether or not she should be detained on the new filing.
Okay, and the new case, as you said earlier, was essentially a bank fraud case?
Correct. It was a bank fraud case, but the facts of both the 18 and 20 case overlapped pretty significantly.
Okay. So let's talk first about the facts of the 18 case. And I know you're limited to what's already in the public record, but can you explain to the court what essentially led to that indictment? Who the victims were, what the scope of the fraud was?
So the 18 case involved a doctor victim in Eastern Oregon, where Ms. Jacobs had lived at the time and had worked with that doctor for many, many years. That case came to us via a referral from local authorities. What Ms. Jacobs was charged with eventually was essentially a multi-year scheme to embezzle from the doctor. The indictment, which was presented to the grand jury and lays out, it's a very extensive speaking indictment that lays out the allegations under the bank fraud charge, essentially alleged that over a multi-year period, Ms. Jacobs, who had full access to all of the books and records of the doctor's office, she was the sole person of trust in the bill paying and bookkeeping area, wrote checks to herself, utilized the credit cards for the companies, and essentially embezzled approximately, the allegation was about $1 million over a few years. And that when the embezzlement scheme was coming to life, and the doctor had referred sort of his finances over to a CPA, Ms. Jacobs had secured loans in the name of the business entity to try and backfill and cover for the missing funds. Part of the embezzled funds were also funds that she had bookmarked as payments to the IRS for taxes. Those taxes had not been paid, so at some point, when the CPA started looking at the books, the doctor eventually received a letter from the IRS noting that the taxes were unpaid. And so there was this question about unpaid taxes. It was at that point that Ms. Jacobs, again, in order to delay discovery, created a false persona, a person by the name of Linda Gibson, and told both the doctor and the CPA that she was helping them with the IRS issue, had spoken with this IRS person by the name of Linda Gibson with a phone number, with a case number, and told them they should communicate with Linda Gibson about the tax problem. There were communications with Linda Gibson, but it was revealed later that Linda Gibson was in fact Ms. Jacobs. And that was in addition to, as you heard in the counts of conviction, she was also charged with personal tax crimes for not claiming the embezzled funds that were her own income. And so that was.
I'm sorry, I missed one point. That she gave the phone number and the name of Linda Gibson to who?
The victim, the doctor.
Okay.
And a CPA.
All right.
So did the CPA actually fall for it? Did he engage in conversation with Linda Gibson, to your knowledge?
Do not believe that is in the public record.
Okay, sorry. All right. So the funds involved here were in excess of $1 million. And this happened over what period of years?
I believe it was a 4-year time period. I have to look at the indictment is specific as to the time period.
Okay. Does the indictment specify, or is there other, as a matter of public record, is it clear where she deposited those funds?
I don't recall if the indictment specifies that. I'm not sure where that would be reflected, but it is likely reflected in the hearings. I'm trying to figure out which hearing we may have talked about that. It may be in the sentencing memos.
Why don't you, why don't you check
I'll
the
take a
documents
look.
in front of you? We have not been able yet to obtain transcripts of all of those hearings, and I apologize.
I don't recall there being anything specific about the accounts that it went into, but again, the admission is that she embezzled for her own benefit in at least 2011 income in excess of $340,000 that went to her personally.
Okay. All right. So moving forward again to this release hearing, did Ms. Jacobs, when confronted with this new bank fraud, did she, through counsel, offer up some excuses or an explanation that proved to be false?
Yes.
Would you describe to the court how that all unfolded and what you were able to represent to the magistrate? I think it was Judge Acosta, not Judge Hernandez, in that hearing about what Ms. Jacobs had actually done. So let's start with what Ms. Jacobs represented through counsel was the truth, and then the refutation that came from you and Mr. Bounds about what your investigation had revealed.
So this was in front of Judge Acosta, who was hearing these. And this is complicated.
Mm-hmm.
And I think the first thing I need to do is explain what the charges were in the second.
In the second indictment.
In the
you're
second
right. Okay,
indictment,
so
or else it won't make sense.
Okay, so she was ultimately convicted of bank fraud, which has a maximum sentence of 30 years in the second case, but of course the indictment would have been a little broader than that. What were the other charges in that second indictment, the 20 case?
So the 20 case charged her with crimes related to embezzlement from a second doctor. And what became clear during that investigation, and unlike the first case, which took many years to investigate, this one came together in a much shorter time period in 2020, once the facts came to light. But Ms. Jacobs, while on pretrial release, managed to get a job working with another doctor. And the charges were bank fraud because she was, it was alleged at the time that while she was working in this office, and it was, during COVID, and so there wasn't a lot of people in the office at the time, checks were coming in from insurance companies to the doctor's office for payment for services. That Ms. Jacobs had in fact stolen those checks and deposited them into her own account. So that was the basics of that particular fraud scheme. And I think it does say in here how much the total amount of those checks were, but they were multiple checks.
Okay, would you refer to that, and would you also see whether it is a matter of public record, whether you indicate that the checks were deposited into her own account, if there is any further description of what her own account means, and whether that was an account that was jointly held or whether that was only her personal account, like whether she was the sole signatory?
I don't have any information about whether or not she is the sole signatory on that time. There may be some information in that transcript from the hearing that is specific to that. But I can tell you, I'm kind of looking to see what this loss amount is here for the second one. So the total amount for the bank fraud in the 2020 indictment, the stipulated loss amount was not less than $47,336.24.
Okay.
So that was the total amount.
Okay, so if I'm understanding the scenario correctly, she is out on pretrial supervision in the 18 case for fraud offenses, and somehow she's allowed to go work for this dentist in Hood River, even though she's already under indictment for these very serious fraud offenses.
Correct.
To the extent that this is a matter of public record, did it turn out that the dentist was aware of the pending federal charge or not when this employment began?
I believe it is a matter of public record, and in this hearing transcript that he did not.
That he was not aware
No.
of the fact that she was on federal pretrial supervision. Okay. So you say that the second case, the 20 case, came together quite a bit more quickly, and sounds like there were a series of checks that were diverted that should have gone into the business account for the dental practice and instead ended up in a personal account on which Ms. Jacobs was at least a signatory and a co-owner.
Correct. And sort of then going back to your earlier question, which was, so what was the explanation provided that is in this transcript, and what was our response?
Right. What was Judge Acosta told by Ms.
Yes.
Jacobs' agent, her counsel?
Yes. So at the time, Ms. Jacobs was represented by Lisa Ludwig. Ms. Ludwig appeared on behalf of Ms. Jacobs. And when Judge Acosta pressed about the allegations that were in the charging instrument, Ms. Ludwig, on behalf of Ms. Jacobs, indicated that Ms. Jacobs had relayed that this was really just a civil matter, that there was a civil suit, that there was a sort of a business dispute between Ms. Jacobs and this doctor, and that it would sort of all be cleared up in this civil suit, and it had sort of taken off. And I was, when I went back and read the transcript, I could sort of read the tone in my voice when I heard that. So what we relayed and what we had learned really over the course of just a few days beforehand, as I indicate in the transcript, was that when the doctor realized that the checks were missing, the doctor hired counsel. That counsel approached the bank, which I believe Wells Fargo, because they were able to determine that the checks had been deposited in a Wells Fargo account. So they approached Wells Fargo and said, somebody took these checks and deposited them. We know it's Wells Fargo. Can you tell us whose account it is? And Wells Fargo said, no, I cannot. So they actually went through the process of filing a Jane Doe suit to determine who was behind these checks so that they could get a sense for where these checks went missing. So the civil suit that Ms. Jacobs alleged to was not a suit that she was a party to, but a civil suit that she was aware of. And it's in the context of this civil suit that we discovered, working with federal agents, that Ms. Jacobs had in fact called Wells Fargo. Because Ms. Jacobs was working in the office, she knew what was happening. She knew about the investigation into the stolen checks, and she knew that the investigation was leading towards Wells Fargo. So Ms. Jacobs called Wells Fargo, stated she was Judy Parker, and made representations to get them to quash the request, essentially representing that nothing else needed to be happening. And again, it's fully in this transcript.
Let me stop you just for a second. When you say Judy Parker, you're referring to the lawyer Judith Parker that we were discussing earlier this morning?
What we knew was that Wells Fargo said an attorney named Judy Parker called us about this.
Okay.
We called Judy Parker and said, "Did you call Wells Fargo?" She said no.
Okay, all right. So where did it take you next, the investigation?
That was really the sort of that was really the key, right?
Huh.
Was just figuring out that there was no civil suit, there was no civil dispute between business partners, that the checks had been taken by Andrea.
Okay. Did you later in the course of that investigation learn that Ms. Jacobs had also made a representation to the circuit court in Hood River?
I'm unclear on that one. I don't remember that as clearly as I remember the Wells Fargo piece.
Okay, all right. So at this hearing, were you able to convince Judge Acosta that she was no longer suitable for release in the community?
Yes, we were.
Did she later obtain release again, or was she held essentially nonstop from that point forward to today?
I am unaware of her being released at any time during that. But again, I left. One of the reasons Mr. Bounds came on as I was preparing to leave in September of 2020. And so I know at least that she was held until then.
Okay, all right. Now, did you also, in the course of that investigation, to the extent that you're able to say so, were there other businesses that she had been affiliated with over time that you investigated?
There were many.
Okay.
Yes.
You heard earlier this morning there was some reference to sleep clinic. Were there sleep clinics with which she was associated that you investigated?
There was information that we developed during the context of the investigation that involved some of these. And to the extent that it is in the record from this hearing, one of the things that was raised by Ms. Jacobs at this hearing about why she should be released was that, she had, that the alleged embezzlement from the first doctor was sort of a one-off, and that she had had sort of a clean record, essentially, since that incident. One of the things we presented to Judge Acosta to counter that argument was that, we were aware of the embezzlement against the first doctor, the 18 case. We had now discovered the embezzlement from the second doctor, the 20 case, but we had also developed information about conduct from Ms. Jacobs between those two incidents. I think, as was mentioned earlier, we pointed out that she had been involved in a business called Oregon Sleep Specialist, and there had been a bankruptcy in that proceeding, and we were aware that there was allegations of additional embezzlement, fraud, theft, and misrepresentations in the context of her activities with Oregon Sleep Specialist.
Okay. Were there also allegations, or was there an investigation into whether she committed bankruptcy fraud in the context of the bankruptcy related to that business?
I do not recall if there was bankruptcy fraud allegation, but I know we spent a long time. I know those bankruptcy documents are available in the public record, and we spent a long time looking at them.
Okay. And was there a second sleep business as well?
I'm not sure that's in the public record.
Okay. Are there other businesses with which she was affiliated that were also investigated that, for example, you might have discussed with Judge Acosta in that release hearing or at some other point?
Don't believe we discussed it with Judge Acosta in that hearing.
Okay,
Mhm.
but it sounds like perhaps we should get transcripts of these other hearings.
Or you could ask Medicaid fraud when they show up later today.
Okay, all right. So did your office actually make a referral to Oregon Department of Justice?
I don't recall.
Okay, but the first case, the 18 case, and what, to the extent that you remember, what was, or perhaps it's in the documents there, what were the dates of conduct? What?
May say in the plea petition. Do you have her plea petition?
I do not have that
Okay.
with us here. I think I might have an electronic copy, but that would be hard to circulate.
So in terms of the factual statement in here, the time frame alleged well, false tax return charge obviously was for a specific year. But the aggravated identity theft charge is not later than February of 2015. So there's a pretty large, oh, here we go. Count 15 of the 2018 indictment, defendant admits that beginning no later than January of 2011 and continuing until December of 2015, she devised a scheme to defraud the victim. So that's the time frame.
Okay, so for the first indictment, that's the time frame. It begins in 2011.
Correct.
Okay.
As charged.
And then the conduct that we were discussing earlier that led to the 20 case actually occurred in 2020 while she's working for the dentist.
Correct.
Okay. And then the investigation that you described that I take it was referred to Oregon Department of Justice involving the sleep clinic was in between. I mean, temporally, those facts would arise from the time period in between the 18 case and the 20 case, meaning somewhere in the mid, like 2015.
I can't be certain that that's the nature of their case because I do not know the nature of their case.
Okay, all right. But your recollection of the investigation was that those matters arose between the two cases that you were handling federally.
Well, if Ms. Jacobs was only out of custody during that window, then it would have to be that window of time.
That the Oregon, okay, so let me back up. Maybe I was confusing myself. The 2018 case covers conduct that begins in 2011 and continues at least through 2015, right? And then there's the additional tax, her personal tax return count. Right. And then she's indicted for that in 2018. She's out on pretrial supervision, and at that point, she goes to work for the dentist, and the conduct that leads to the 2020 indictment begins at that point in time in 2018. So to the extent that you know, do you believe that the facts underlying the Oregon Department of Justice investigation are in that gap between, say, 2015 and 2018?
And again, I don't know anything about the nature of their charge, but in looking at the transcript from the hearing, we do reference Ms. Jacobs' association with a company called Access Sleep, in addition to the separate reference to Ms. Jacobs and Oregon Sleep Specialist in there.
Okay, right. So both of those sleep businesses are referenced there in that.
Yes.
Transcript. Okay. All right. So you were assigned during the time that you were in the Department of, you were working at the U.S. Attorney's Office here. You were primarily in the fraud unit, were you not?
That's all I did. I was hired into the fraud unit. I remained in the fraud unit. I had some specialties in healthcare fraud and elder exploitation.
Okay. But how many people would you estimate you prosecuted during your time with the U.S. Department of Justice?
Oh, I would not speculate as to that number. I mean, obviously we carried large but intense caseloads. I mean, this was a multi-year investigation into Ms. Jacobs.
Right, and the fraud cases tend to be really big paper cases, do
And
they
long.
not?
Mhm.
Okay. What makes you remember the facts of these cases so well?
The facts of this case were somewhat extraordinary in terms of the repeat activity. There are charges we file frequently: bank fraud, aggravated identity theft, wire fraud. I had never filed a impersonation of an IRS officer charge. It is a rare charge. So that really stood out. Also, to have 2 cases in a row with the same person that involved embezzlement from a doctor and then the impersonation of someone else to cover that up were extraordinary. The fact that we sought detention and received detention was also fairly extraordinary. I don't know how many people I have prosecuted in the federal system, but I have only sought detention in, I think, 5 matters where there was this type of repeat behavior that seemed not to be deterred by charges and being found out. And so we, as I argued at the hearing, I really did believe that she posed a risk of continued lying. I think, as I said in the hearing, the fact that she says something is true has no bearing on the truth, and that there has to be something else for Ms. Jacobs, because she has shown herself to be such a prolific and skilled liar.
Thank you. No further questions.
Sure, thank you. Ms. Maddox, it kind of sounds like we're re-prosecuting Ms. Jacobs in this hearing. I'm certainly not here to defend her, but I just want to make sure I kind of understand a couple of points. And so you stated that she had a certain max exposure. I know that federal guidelines, I think, are way more complicated than even the state guidelines, which are complicated enough. But nonetheless, she pled to, it sounds like, 4 charges over 2 cases, and her exposure to those 4 charges were 51 to 57 months.
That seems likely, depending on the, how the aggravated identity theft
Sure.
pled out, because that's 2 years on top of whatever the other calculation ends
Right,
up
and I
being.
pulled that number out of the sentencing memo, so does that sound right?
Yeah,
Okay.
and if it exists in the sentencing memo, just please point me to it.
Yeah, I'm not trying to catch you. It says right on page 5 that the advisory sentencing range is 51 to 57 months.
Then that's it.
Prison. But the government actually recommended a downward, we call it a downward departure in state court. In the memo, it says a downward variance. Why would the government request the court impose a lesser sentence than the range in this case?
I don't recall what the negotiations were that brought us to this. And again, I was still at the office at this time. What I can tell you, and what I think, well, 2 things. Imposition of sentences in fraud cases in not just the Ninth Circuit, but in the District of Oregon tend to vary greatly down from the sentencing guidelines. So it's not uncommon to go to trial and to still get a very significant departure, and so we take that into consideration.
Similar in state court.
The other, as you probably remember, is this is COVID time.
Mm-hmm.
And there were COVID considerations about moving cases.
Okay. And so even though she's this prolific fraudster, there's still other things that go into it that would have you treat this case like other cases.
Can you clarify your question?
Yeah, I mean, I know, and I know you know, but for the purpose of the record, what goes into plea negotiations? Many factors.
Many
factors.
Many factors.
But nonetheless, you tend to, or you strive to try to treat similarly situated people the same.
Yes.
Yes, part of it. You actually have a duty to do that.
Correct.
Is that correct? And so when considering Miss Jacobs and the crimes that she committed and the many other factors that go into plea negotiations, including one's willingness to take responsibility for their crimes, in this case, the government not only allowed her to plead to just 4 charges that could only result in a range of 51 to 57 months, but they actually recommended that the judge impose a lesser sentence than that.
Correct. Again, that would be, in a fraud case, pretty
They're
standard.
pretty common, yeah. And that was no different with Miss Jacobs.
Yes.
Okay.
Yeah, and I will say 4 years for any fraud crime in Oregon is actually pretty significant. The largest fraud crime I ever had was $15 million loss, and a contested sentencing resulted in a less than 9-year sentence.
Right. That was the biggest one you've prosecuted.
Yeah, for me personally. And again, in the fraud landscape, it's all driven by loss amounts in terms of seriousness.
Sure. And what about in your office? Are you aware of cases that are even bigger than that?
Oh, there must be.
Yeah.
Yeah.
I'm not going to ask you specifics, just that you
Sure.
do recall that there were cases that were even bigger than the $15 million 9-year case. Okay. And as part of that plea deal, again, one of those other factors sometimes is that people will enter into cooperation agreements, agree to testify against others, things like that. Was that was that a factor in this case at all, or these cases at all?
That was not a factor in this agreement.
Okay, in this agreement, Ms. Jacobs was not agreeing with the government to provide any sort of testimony or information to the government in exchange for a lesser sentence.
Your Honor.
In terms of this agreement, no.
Okay, but I mean, I think that's part of what we're trying to figure out here. So
Not in terms of this agreement. But she did not get this deal based on any agreement that she was going to provide information.
okay, and just as an aside, are you aware, as your time at the U.S. Attorney's Office, and even since you left, that Ms. Jacobs was engaged with the state with attempting to sort of garner some favor?
I will say this, I can only answer your question as to what is in the public record. And I'll have to leave it at that.
Okay. And just in terms of some of these other factors, was some of the factors too that you took into consideration when making that recommendation to the court that Ms. Jacobs was 49 years old and had no prior criminal history?
Correct.
And that she was, I think I sort of already mentioned this, but she was willing to take a plea deal and admit some responsibility.
At that point,
Right.
yeah.
And then it sounds like obviously committing a new crime while on release is kind of the ultimate no-no that'll get you brought back into custody or make things a lot worse. Other than that, and I'm not trying to downplay that, just other than that, were there any other violations of her release that you were aware of?
As I state in the transcript, there were issues with her being transparent with pretrial regarding her finances, and
Right.
quite frankly, financial supervision is just difficult.
Yeah, of course. But as far as showing up to court, being where she's supposed to be, things like that, she was compliant.
In other respects, she never failed to show up for a hearing.
Okay. I don't think I have any other questions. Thank you, Ms. Maddox.
Can you redirect?
Yes, Your Honor. In the context of what you were just reporting about this sentence, criminal history in the federal system, that actually means convictions. It doesn't mean all criminal conduct, right?
Correct.
Okay. And there's another concept, we call it relevant conduct, that addresses what may have been unprosecuted criminal conduct. But when you were answering the question that Mr. Overstreet asked you just now, you were talking about the fact that these were her first convictions. Of all the activity that we've discussed today, the only ones that have actually led to convictions so far are the 2 federal cases.
Yes, she had not had previous criminal convictions other than these 2.
Okay. And is it fair to say that 4 years for somebody who is coming before the court, not having previously been convicted, is considered in federal court for a fraud offense? Pretty serious pretty serious sentence.
As I said, that was, in my experience, a pretty significant sentence.
Okay. Now, in the federal system, because sentences can be so very, very, very long, there is a great deal of cooperation that's just a big part of the system, correct?
Yes.
Okay. And because cooperation is in the federal system also a very dangerous proposition for defendants, for the informants, we've developed a system of disguising that.
Correct.
So the public record is designed essentially not to reflect cooperation.
Correct.
And likewise, the public record, it would be exceedingly unusual to have the public record reflect an attempt to provide cooperation.
Correct.
So the fact that you are testifying today based on information in the public record and they have not disclosed any attempt to cooperate in the federal system, that doesn't reflect one way or the other on whether any such attempts were made. You simply are not in a position to address that today.
I can't speak outside the public record.
After that hearing that you were discussing earlier with Judge Acosta, that release hearing in which her supervision was revoked, she was brought back into custody and eventually met our client.
Technically, it was delayed. He didn't make he held her for a couple days pending additional investigation by defense counsel. So the determination was not made that day, but Ms. Ludwig conflicted off the next day, and then Judge Acosta made the determination.
Okay, and that's what I was going to ask you. Did Ms. Ludwig in fact resign from that representation the very next day?
It was the day or two after, yeah.
All right. I think that's it. Thank you very much for coming in.
All right, thank you. And let me ask defense, it's 10 to 12. Does it make sense to start another witness or come back at 1:30?
Probably.
I will tell, I don't know if Mr. Overstreet's aware of this. We were supposed to have a hearing at 1:30. We no longer are going to have that hearing today. So that means we can all come back earlier unless you have other obligations. Can each side be back at 1:30?
Yes.
We can, and I am aware of that.
Okay, all right. All right, then we'll be in recess till 1:30.